which unfolds itself as time passes by in the given environment which we find ourselves in. Therefore, it gives me a great happiness to be on the panel, as it encourages especially a relevant discussion for a world that is finding ways to go increasingly virtual, there being very little else options. The 21st century is no stranger to technology. The fast-paced life that has become a characteristic of this century finds its bulwark in the rapid changes and innovations in technology. Having become both a cause and an effect of the lives led in this millennium, technology has entered all forays of our life, and we have learned to not only embrace but also rely upon it heavily. The true moments of reckoning for technological innovations have, however, risen in the past few months, when the virtual touch was the only one declared to be safe for all. With every aspect in our life witnessing a new normal, each field has tried to cope with devising novel mechanisms. Courses have gone online, classes are being conducted on the internet, and even political rallies are trying to dominate the virtual world. Thus, the dialogue to develop technological tools to fill the void that has been created due to a microscopic living organism has taken precedence in these days. Panel discussions like the one today are the need of the hour to discuss tools that can be used, especially in the business world, to help tide over these testing times. One of the leading needs for any enterprise is for an environment where all aspects are allowed to run smoothly and expeditiously. It is in this light that e-contracts and technology of e-signing need to be appreciated. So let's begin by what is an e-contract. The International Chamber of Commerce refers to electronic contracting as the automated process of entering into contracts via the parties' computers, whether networked or through electronic messaging. E-contracts can be entered into via email or through the World Wide Web through what are known as the website-based e-contracts. These can be of three types, the click wrap, the browse wrap, and the shrink wrap, each of which are distinguished by mechanism for accessing terms and expressing consent. I'm sure these would form a part of the discussion of the panelists, and therefore I'm not getting into details of each one of them. The electronic contracts which held legal ground need electronic signatures. The technology of electronic signature is up and coming, and however, there is a slight cloud of mystery that lingers over this concept. To dispel this cloud, in 2008, the Information Technology Act of 2000 introduced the concept of electronic signatures in order to align with the UNCITRAL model law on electronic signatures, which established the criteria of technical reliability for achieving the equivalence between electronic and handwritten signatures. Electronic signatures or e-signs have thereafter been encased in a sound legal framework in India, with the exception of legal instruments lying outside the purview of the ITE Act, such as negotiable instruments, trust deeds, wills, and other testamentary documents, which require a formal notarization process. E-signs have found a sure-footed presence in the e-commerce world. As with anything new, trepidation in their use is warranted. However, it is important that there is an adequate awareness of the same in order to build confidence of users and to help them take advantage of the many operational benefits of the technological tools at their disposal. Let us analyze the benefits operationally of such e-technology or the e-signature technology. I would put them in various categories, starting with it is both time and cost efficient. Prima facie, the intuitive understanding of e-signs has one inferring that the biggest benefit lies in the fact they are simple and easy to use. There are a number of different online solutions where signing can get as simple as this. A document needs to be uploaded. Signers and recipients need to be declared. A secure link is delivered to the recipient. The recipient signs the document by merely opening the link and clicking on the button, and the process is complete. As opposed to the traditional contracts, the signing of which involved several stages: printing, signing, scanning, sending via email, fax, or courier for electronic agreements, contracting parties just digitally sign the contract and they send a copy of it to each other. The cost of paper, printing, ink, etc. gets excluded as well, making the technology easy on the watch and on the pocket. It is again, with the passage of time, it is available anywhere. The ability to electronically sign without meeting anyone gives the privilege to stakeholders to sign documents anywhere and anytime, and this becomes of great importance in the current scenario where movement from place to place is the question mark, more so inter-countries. It allows for quicker decision implementation. Enforcing decisions in business usually has to undergo a long phase where several documents need to be signed and approved by varying stakeholders. And naturally, the more time the signing and approval process will take, the more time it will take for the decision to be implemented into action. By speeding up the formalities surrounding the approval process, eSigns shorten the gap between a decision and its implementation. Thirdly, it provides enhanced security. As will be discussed as length subsequently, eSign platforms are so structured that they ensure the security and sanctity of the contract agreement. It next simplifies and automates document management. With a system of eSign, the problem, especially with complex contracts of filing several documents, their classifications, maintenance, and even scanning is replaced by automated processes. With most aspects getting automated, the scope for mistake is lesser. And lastly, in an era where there is once again a focus to the human race becoming more e-friendly and the Almighty possibly putting the human race inside to get a chance to the remaining species and the natural habitats. The eco-friendliness of the system, promoting a cut down in use of paper resources, etc., e-signing allows for a more economic friendly process. It is this quite evident that by having facilities available for e-signing and concluding the electronic contracts, a truly paperless and contractless contractual world can be envisaged. It is evident that the eSign technology makes businesses more productive. However, for businesses to really take to this technology, an important component that needs to be addressed is the legal acceptability of this technology. We can turn to the legal regime now. And in this light, it is important to understand how our domestic legal regime enables the eSign and the eContract technology to thrive. Firstly, however, it is pertinent to understand the function of eSigns in order to better realize the magnitude of their legal recognition. The functions of a signature are A, to identify a person, B, provide certainty as to the personal involvement of the person of the act of signing, and C, associate such person with the content of the document. Under the IT Act, Section 3A permits a person in whose name an electronic signature certificate is issued to authenticate an electronic record by way of inter alia, an electronic signature, which is considered to be a reliable subject to certain other conditions within the IT Act. Section 5 then goes on to accord legal recognition to the electronic signature, ensuring that as long as the functions of a signature are being performed, an electronic signature is part with the handwritten or the wet ink signature. As corollary to the legality of electronic signatures, Section 10A recognizes the legality of electronic contracts. While the Indian Contract Act does not exclude electronic contract, per se, Section 10A specifically provides for that. So if an electronic contract adheres to the criteria of a traditional contract, the same will be recognized as valid in the eyes of law. The recognition has ensured a greater acceptance towards e-contracts and consequently has attracted businesses and commercial platforms to use them. In India, the Aadhaar eSign is the accepted method of securely e-signing documents. Its inclusion in the second schedule of the IT Act has granted it the recognition of being equivalent to a vetting signature. Consequently, entities like SEBI have prescribed the Aadhaar eSign for attesting documents during their customer due diligence and online KYC process. Now, I believe that a discussion on the legality of eSign remains incomplete without addressing a common assumption in the electronic world, that it is not difficult to alter the contents of electronic record, an e-agreement or e-contract which is stored or recorded in an electronic form. It is essential that we deconstruct this assumption. This can be done by ensuring a certain degree of security is present while using electronic records and electronic signatures, as delineated in Section 14 and 15 of the IT Act. Under the Indian Evidence Act, Section 85A deals with the presumption as to electronic agreements, that it enables the courts to presume that every electronic agreement contains the electronic signature of the parties, is presumed to have concluded upon affixation of the respective electronic signatures. Section 85B concerns itself with presumption as to electronic records and electronic signatures. It provides that in proceedings involving a secure electronic record, the security of the same is to be presumed by the court unless proved to the contrary. Similarly, in proceedings involving an electronic signature, it is presumed that the secure electronic signature has been affixed by a subscriber with the intention of signing or approving an electronic record, unless proved to the contrary. That is, the moment an electronic signature is secure, the intention of the subscriber is automatically presumed. Since the presumption under Section 85B pertains only to secure electronic records or secure eSigns, their security features are of vital considerations. Having said that, I return to the example of the Aadhaar eSign. Given the presumption existing in favor of the authenticity and correctness of eSign under the Evidence Act, the Aadhaar sign is more likely to be secure than a physical signature and is completely admissible in court. As a corollary, all agreements executed with an Aadhaar sign come with a legal backing. This makes such agreements easier to enforce in court of law and less susceptible to legal challenges. The case in enforcing eSign agreement also stems from the fact that such documents are easier to use in evidence. To understand their assessment as evidence, we must direct our attention to Section 65A and 65B of the Evidence Act. Section 65A clarifies that the contents of an e-document can be proved, and Section 65B provides the conditions that need to be fulfilled to prove an e-document. It allows for information contained in an electronic record to be deemed as a document and held admissible as evidence in any proceeding without further proof of the original document, subject to the fulfillment of certain conditions regarding the health and operation of the computer on which the e-document in question was stored. Thus, the scheme of the aforesaid sections and of the Evidence Act makes it quite easy to use e-signed documents in evidence. A copy of the e-signed document is to be provided along with the audit trail. A certificate to signify the authenticity of the document is to be furnished too. Things go further simplified insofar as proof is concerned regarding the aspect of authenticity and security of the data provided due to the input of technology in the entire process. If a digitally signed document is tampered with, then the digital sign will break, making it evident that the document has been tampered with. Now, digital signature doesn't really break. Rather, it fails to verify, among other things, that the data in the signed document did not change after the signing. In fact, Many such platforms offer a temper evidence feature, wherein if any changes are made in the eSign document, they are noted, automatically providing proof of the same. eSign platforms also provide the technology that gives information about who signed the document and when. With these technologies in place, it becomes easier to use eSign documents for evidence. And even if there have been multiple signatories to a document, all the evidence has been recorded by technology and is available. Thus, the integrity and authenticity of the document can be proved fairly easily. Turning to the ADR, and which is an important aspect in times now, and debate has been taking place on how to use forms of mediation and other with the online process in this ADR system. Let us examine the eSign documents in this ADR process. As e-contracts have become a staple of today's commerce world, synchronizing the operational framework of the e-contracts with the legal requirements of dispute resolution mechanism assumes significance. Arbitration is a preferred mode of dispute resolution in e-commerce for various reasons of flexibility, of forum facilitation in the cross-border dealings, and swift settlement while avoiding the risk of litigation. It therefore becomes essential to ensure that the arbitration clause in an e-contract meets all the requirements of enforceability, both by assessing it from the point of view of international agreements that set out rules relating to arbitration, as well as the legal systems of different countries and their individual requirements. In ensuring the validity of the arbitral clause, the user has to be satisfied on two accounts. Whether the electronic contractual process really allows for the informed consent of the parties, and secondly, whether such a clause meets the requirement of a written one. Some answers are to be found in the international frameworks that have been developed to deal with such anticipated hurdles. The UNCITRAL model law on electronic commerce has given consideration to possibilities of dealing with impediments to the use of electronic commerce posed by the requirement in the national laws. This model law stresses on functional equivalent approach, which is based on analysis of how the purposes or functions of the traditional paper-based requirements could be fulfilled with the use of the electronic techniques. In India, Section 7 of the Arbitration and Conciliation Act 1996 requires that a valid arbitration agreement be in writing. However, Section 7 does further clarify that an agreement would be considered as having been in writing if it has been communicated through an electronic means. While the term electronic means has remained undefined, even post the Arbitration and Conciliation Amendment Act of 2015, Section 10A of the IT Act comes to aid as it gives validity to contracts which are formed through the electronic means. Most recently, in the wake of the COVID pandemic, international arbitration institutions have formulated fresh protocols to keep the wheels of dispute resolution running while ensuring the need for social distancing. And many have seen embracing and giving official recognition to the electronic modes of the arbitration agreements and awards. The International Chamber of Commerce, in its guidance note, has provided for certain procedural tools in reference to the continuing operations in the post-COVID world order. One such tool is set out in Section 15, which provides for the possibility for the parties to agree that the process of signature and service of the award is done electronically, obviously subject to respective national laws that may be applicable. If we turn to mediation, I was party to a recent webinar on this issue where the concerned government departments are seriously concerned with the possibility of more disputes arising in the post-COVID phenomena, and how, whether it's the government entities or the banks or others, can help in solving these problems quickly through an online mechanism and giving a greater central force to a process of mediation followed by arbitration. So, though India has largely been in the sphere of opt-in mediation, where parties have to voluntarily give consent. The other line of possibility is the opt-out mediation, where you must first almost be compelled to at least participate, though conclusion of the mediation is not something which can be forecast. So you have amendments to the Consumer Act, to the Commercial Code Act bringing forth. And there is a serious concern now being expressed that possibly we need a centralized mediation act, to which I may say the MCPC of the Supreme Court is also concerned as set up committees. So all of us are concerned with providing an expeditious remedy in this post-COVID phenomena, because otherwise in the overburdened legal systems which we have, we will certainly see a great expansion of the commercial litigation. And my personal belief is that such online mediations or settlements or processes, not spreading the net too wide initially, should be concentrated on seeing that the online, these processes are utilized for the post-COVID disputes at the first instance, so that they don't become another backlog in the system which you already have. And those can be resolved expeditiously. Of course, not taking away from the fact that all these processes are good even for the pending disputes or in other contracts which may be in question. Therefore, the current situation arising out of the COVID-19 pandemic provides an added impetus to facilitate the electronic modes of functioning and dispute resolution, and a justice delivery system around the world goes online. The predicament we all now face is unique, but it is also an opportunity for us to leverage the technology that has for long been at our disposal. The legal field has been so far not so fast to adopt technology as some of the other fields. But I think we are, the situation and the circumstances are forcing us to do this. So the time is ripe for initiating a dialogue and bringing attention to the opportunity that lies at the intersection of law and technology. I thus applaud the effort being made today to facilitate a wholesome understanding of the legal framework of e-contracts and e-signs. I'm certain it will go a long way to paving the path for a robust legal regime that is equipped to deal with the challenges of future. And as the American President John F. Kennedy once said, change is the law of life, and those who look only to the past and the present are certain to miss the future. Thank you for this opportunity.